Proud Boys trial, it continues with the jury deliberating, and we have some activity today. Several different jury notes came in, as well as 2 different filings that came out on behalf of the defense team. One on behalf of Dominic Pezzola, who we heard from on trial, actually got up there and testified, and another one from Ethan Nordine asking the court to declare a mistrial. Now, as you can imagine, these motions aren't really likely going to be fruitful, but they're still declaring and showing us, revealing for us, a whole bunch of additional information that will be useful. So let's see what the jury is talking about today. The very first note came in, it looked like this one, a note from the jury. And you see the handwriting of this person, and you see the punctuation of this person. We see exclamation points. Big fan. Says, hi, could the government please remind us of the 2 exhibit numbers that we're looking for here? One, the video from Real's phone crossing the barricade at the breach. What exhibit was that? You got like a million of them for us. Which one was that? And number 2, the video where Biggs suggests they pull up their masks. Thank you! Exclamation point. 4 persons signed off on it, but the name's been redacted. That came in on April 26 at 4:35 in the evening. So that got filed, but that actually came in yesterday, the day before. So here, 2 different questions. The video from Real's phone crossing the barricade at the breach. So they're saying, okay, we want to recreate that scene and see who was where and who did what and how did it all go down. What exhibit was that? They want to go look at it again. It came up in their discussions. Similarly, the video where Biggs suggests they pull their masks up. Uh-oh. Why? To hide your identity as you're committing an insurrection? Uh-oh. So are they doubting that? The video suggests that they pull their masks up. Sort of can imply that maybe they're thinking that Biggs is trying to conceal something. So that's the question that came in. What 2 exhibits do you have for us? And the judge responded, here are the 2 exhibits. 1, the exhibits that are responsive to your 2 questions are indicated on the attached copy of your note. So the judge just took their note and listed them, said here, Government Exhibit 400D and Government Exhibit 1001 at time 9:50. And to your second question, you're going to see, you can find that in 2 different exhibits, 404K and 404KX. And so both those notes went back to the jury and they're going to pull those up and they're going to run through them and see what the heck is going on. That's the first set of notes that came in. Then a second set of notes came in from the jury, and they said the following, but this handwriting's a little bit different. This is a different person. They're requesting the following. 1, evidence exhibits. They want a copy of the police shield, the U.S. Capitol Police riot shield. They actually want to see the thing. Bring it in here. They want the Proud Boy megaphone, and they want the MOSD, which is the Ministry of Self-Defense leader, and the membership chart. And that chart was something that we think we saw in court, but I don't know that that was ever admitted as evidence. But they do want to see the shield and they do want the megaphone, which is interesting. Why do they want to see the shield? Do they want to validate Dominic Pezzola's claim that he was using it to guard himself from the police projectiles that were being shot at people's faces and verify whether that's true or not? They want to see is it flimsy? What's the deal? You know, they want to inspect it, but it's the actual shield. So the judge responds and says the following, sure. No problem. You will be provided the riot shield and the megaphone, but the chart you reference was not an exhibit admitted into evidence. So they wanted some of the things that they were just putting up on the screens, but that was just to demonstrate what was going on. It's not actually evidence. So they do get the riot shield. That is evidence. That's going to be coming in. And the megaphone will be coming in so they can test it out. Whose house? Our house. Whose house? Our house. You know, in the jury panel. They're like, wow, this is very insurrectionary. Do you feel insurrected? Oh, I feel insurrected over here. Put that down. Somebody might take over the jury panel, actually, now that I think about it. Whoever requested these items is probably, the judge better be careful. This person might take over control of the whole courtroom, now that I think about it. If he gets his hands on the riot shield and the megaphone, Lord help us if he gets control of the podium. We're all doomed. The whole building is going to be taken over. SDNY will be in the hands of this juror. So, all right, well, the judge is playing with fire on that one. We also have another question that came in from the jury. It says, our drive is missing an exhibit, 490A. Big file. What is that? It says, can we please get someone to check our drive or add this to our drive? It's a big file. We can't see it. And they say, oh, and can we also get a stapler too? Because we got some stapling to do, baby. Signed off by the foreperson again. And is this the same handwriting as note 1? All right, so the point is, we've got another note that came in and the judge responded, you will get the exhibit back. It's exhibit 490A. And you're also going to get a stapler. And we'll give you extra staples too. We know how finicky those things can be. So all of that went over. The jury is no longer in session. So they asked questions. Roger Parloff, who has been covering this trial, doing an excellent job, tells us the Proud Boys jury has been excused for the day. They come back tomorrow at 1:30 p.m. because of a juror's appointment. They've got something to do in the morning. Beginning to sound doubtful that we'll get a verdict this week, he says. Very curious from inside the arena from Roger Parloff. Now, there was another exhibit explanation from Roger. He tells us that Exhibit 490A, the one that the jury referenced, is a huge video file, 26 gigabytes. I didn't download it because it would take too long, but it shows Enrique Tarrio coming out of a DC jail on January 5th and being greeted by various women, and guess who? Dum-da-dum-dum, Kenny Lizardo. So the jury wants to see that video. That's great news that they want to see who that dude is, Kenny Lizardo. Who is that guy? They're thinking this through. They're looking at the evidence. They want to inspect the shield, and they're walking through the evidence, which is just great news. And I don't want to, get anybody's hopes up or anything. It's way too premature for that. But they're looking at a video that had nothing to do with January 6th, really. This one was on January 5th. And it's Enrique Tarrio leaving the jail, being picked up by a confidential human informant source for the FBI called Kenny Lizardo. So they're looking at it again. All very good stuff. So that is the update on the jury notes. Now, there were a couple very interesting filings that came in, and these were the motions for mistrials and motions for curative instructions. And I want to give a hat tip over to Julie Kelly on this one. She had a great tweet about it. She says, very interesting motion came in, was denied, of course, by Judge Kelly in the Proud Boys case. That's now with the jury. Pezzola snarked about Ray Epps when he testified, but a prosecutor during closing arguments told jury that accusations that Epps was a Fed was a fantasy. Like, there's no evidence about this at all. And that's a very dishonest thing. There's plenty of evidence. We've talked about it here. There's a whole litany of reasons why Ray Epps is a questionable figure in this whole ordeal. And to be so dismissive of it is nonsense. You can say, well, he's a former member of the Oath Keepers. They got prosecuted. He is somebody who was there the night before screaming going into the Capitol. Many others are being charged with conspiracy for doing a lot less than that. We had a situation where he actually went into the Capitol building and told that to the January 6th select so-called committee. And the FBI had him on their most wanted list of violent people after the insurrection. The tweet is still posted up on their field office. So with all of these different things, it's not a fantasy at all. That's a mischaracterization of this. One of Pezzola's attorneys disagreed with this and submitted a motion. Let's take a look at it. This came on behalf of Dominic Pezzola. They say, comes now Dominic Pezzola asking for a curative instruction to fix something that happened. This is regarding the role of unidentified persons, possible informants, and confidential human sources. The proposed instruction is necessitated by assertions, claims, and arguments made by the government during their closing arguments. He writes, this is Roger Roots for Dominic Pezzola. He says, for example, prosecutors, the government, stated during their closing arguments a few days ago that Pezzola's testimonial speculation that Ray Epps may have acted on behalf of the government was a fantasy. Pezzola took the stand and he said something about Ray Epps. The government rebutted that in their closing arguments. This is addressing that. Now, such an argument is not based on the evidence in this case. Mr. Epps has dodged a subpoena in this case, says the defense. And we've covered that. The defense asked for a subpoena that could be served by publication, meaning they could post this somewhere. The judge looked at the rules and said, you really can't do that in a criminal case like this. And he's right. But the point is, the rules don't afford it, but doesn't mean Ray Epps was being a cooperative witness in this case. If he was somebody who really wanted to clear his name, as he apparently wants to do because he shows up on 60 Minutes, a good question would be, why doesn't he respond to a lawful subpoena that was signed off on by a judge? They can't serve him. The judge issued a subpoena, but they can't serve him with it because he is nowhere to be found. So they wanted to try to serve him by publication. The judge said, no, I don't have the authority to do that. And I think the judge is right on that. But that doesn't exonerate Ray Epps. Moreover, the government has never categorically denied Epps was a source for all agencies. Now, he writes, in a recent interview in an episode of 60 Minutes, which was ridiculous, but Mr. Epps emerged from hiding for a Puff Piece softball interview, they say. The 60 Minutes interviewer asked a suspiciously specific question as they do, along the lines of, "Did anyone in the government tell you to go to the Peace Monument?" Epps said no. Then at the end of the segment, 60 Minutes reported that the FBI stated that Epps was not an employee or a source for that agency. See how careful that language is? Ray Epps is definitely not a source for the FBI. That's ridiculous. No. He's never been an informant for the FBI. Never. Okay, but how about the rest of the government? Is he a source for Department of Homeland Security? Well, look, this is a total conspiracy. There is no evidence at all that Ray Epps is an informant, and nobody's ever confirmed it. And this I can tell you unequivocally. He is definitely not an informant for the FBI, okay? That's not what we asked you, weirdos. We want to know the whole of government. Does he work for you in any other capacity as a source? They don't want to answer that question. And these people at 60 Minutes, which, as we know, the media is basically writing scripted questions and handing them back and forth between this administration now. The 60 Minutes conversation should have asked another question. Okay, not the FBI. What about DHS? You working for them? You working for any other agency? There's like 34 of them there in DC. Can you pick one? Can you affirmatively tell me that there is no relationship with any other federal agency whatsoever, period? Unequivocally, everybody. Go. So you can say it at the same time. Ready? Go. No, they won't do it because they know it's not true. Mr. Pezzola and his attorney say the government has refused to say whether Epps had a reporting relationship with HSI, which, as we know, which came out in this trial, is known to have handled CHSs on January 6th. And the court has denied efforts by the defense to inquire about these questions. It's not relevant. It's a whole separate agency. What do they have to do with anything here? They say they're not even case agents here. The FBI did the investigation. The FBI is prosecuting this. Confidential human sources are irrelevant. The defense argues that the evidence reveals several other suspicious actors who played destructive or instigator roles, but who are not identified. A significant example is the man in the red who first broke the window which Dominic Pezzola is accused of breaking. That individual is known to have been present at nearly every breach and was even next to Ashley Babbitt at the time of Babbitt's murder. Yet the government has not identified or charged that person. The man in the red. Who is that person? Footnote 2, the man in the red who first broke the window would likely have been the second person into the house corridor if Ashley Babbitt had breached the corridor. No charges for him. No identifications for him. Curious. Now, the government's closing argument therefore misleads the jury, writes the defense. Pezzola asks for a curative instruction to correct this along the following lines. They want the judge to tell the jury to say, hey, jurors, during the trial, you've been informed that undercover confidential CHSs of the government may have been involved in events. Now, there has been speculation and testimony or evidence that individuals other than the defendants may have played roles in the formulation and execution of the crimes in this case. You should disregard any assertions regarding whether a person is or is not a CHS unless those assertions are based on evidence, and you may draw an inference that the identity of unidentified or missing significant participants in criminal events or circumstances where the government likely knows the participants' identities, if you knew them, they would be unfavorable to the government. So saying the government knows who these people are, they're not telling you who they are. They played a significant role, a major part in this crime, and you can hold that against the government. Because as we talk about, think of it like a pie chart. If there's 1,000 people who are charged with crimes for an insurrection, who's really responsible for the insurrection? In this case, we want to know who is responsible for the initial breaches, most of the damage, right? The biggest cause of the interference with our democracy, as they say. We want to know that. Who is it? So if we can apportion liability and say you're 50% responsible and you're 50% responsible, then great, we can charge people with crimes and apportion it appropriately. But when you break it out by 1,000 people, or when you say the Proud Boys did it, but then we say, oh, what? There's also 50 other CHSs that have been rumored to have been a part of this. And there's also the man in the red who is at every other breach as well. So maybe they should be apportioned some percentage of this blame and not the Proud Boys. And if the government's not going to tell you about these other people, then you can take that sliver of blame and give it to the government. Give it back to them. Don't give it to our clients. Respectfully submitted, Roger Roots, Certificate of Service, signed April 25th, 2023. Now, as Julie Kelly told us, the judge very likely took a look at this and he said, get out of here. What are you, nuts? denied. Next, and threw it right in the garbage, maybe in the shredder after it got put on the court docket. But the point remains, unidentified people who were right next to the defendants when they were accused of committing these heinous seditionist crimes, not charged with anything. We still don't know who the pipe bomber is, right? Where's that guy? All of them are not found. We don't know if they ever will be found, but we do know the government got the people that they wanted and they charged them accordingly. There was another motion for a mistrial. This one came in on behalf of defendant Ethan Nordine. This is 6 pages long. This is Ethan Nordine's motion for a similar argument for curative instructions or in the alternative for a mistrial. Now he says, Your Honor, back during closing arguments, the government delivered a rebuttal argument. And he says 4 subject areas had improper argument. We want curative instructions and a mistrial. First, the government need not prove the defendants agreed to any plan, which is a mere detail of a conspiracy. So this is kind of a technical argument. In multiple places, the jury instructions correctly treat the terms appropriately, and he's referencing the jury instructions. But during closing argument, the court suspended Nordine's argument to admonish his lawyer that he couldn't make arguments to the jury based on the DC Circuit law. And that's exactly what happened. We were reading through the closing argument, and the judge excused the jury, and he did admonish him, and he said, how dare you put that slide up here? That's not what the law is. And I get to decide what the law is. The court commented to the effect that, quote, the essential nature of the plan standard was just dicta from that case, which means it's not actually law. Dicta is like, it's just opining. It's in the case, it's in the opinion, but it's not controlling. It's just somebody saying something that's kind of irrelevant. And so if you extract it, you say, okay, that's a nice sentence you took from that opinion, but that sentence had nothing to do with the actual holding in the case. Therefore, it doesn't hold, it doesn't apply. The law is not that. The law is this. Saying it's just dicta, but the defense says that's not correct, Your Honor. The DC Circuit Court has applied the essential nature of the plan standard to conspiracy cases since the 1980s. And the facts in a Hemphill case show that the essential nature of the plan formulation has bite, and it's not superfluous language that the court can just throw away as dicta. It actually means something. Explaining why sufficient evidence established the defendant's guilt on a conspiracy charge, the Court of Appeals cited evidence showing his execution of a plan was sufficient. So the government, when the government made it a central theme of its rebuttal that it doesn't need to prove that any Proud Boy understood or agreed to any plan, it was misleading the jury as to law. They don't need to have a plan, they said. They don't even need to have understood a plan. Whatever. It's like close enough. So as the court points out, this is an issue that goes to the heart of the case, directly to the conspiracy charge. And the government's rebuttal used this inaccurate statement of the law to bolster their credibility of Bertino. So this improper argument is not somehow harmless. It injected a semantic distinction between the word plan and agreement, and it goes without saying this is going to cause confusion for the jury. So the court should read a curative instruction that gives the jury an accurate description of the standard. It says the prosecutors also misled the jury about a sentence being imposed. In the rebuttal close, the government prosecutors suggested that Nordine misled the jury about a potential prison sentence. Nordine argued that Bertino may have pleaded guilty to seditious conspiracy, and the government purported to disprove this by saying, no, it's a bigger statutory penalty. Here, the government misstated the law and again misled the jury. And we have finally the fourth rebuttal. This is they're saying that the government in their closing arguments said that the Proud Boys, quote, almost destroyed the Constitution. Wow, did they? Is the US Constitution in there readily available to be destroyed? Did they get their hands on it? Was it next to the podium? Now, the prosecutor said this, and the defense says this remark being delivered near the close was grossly inappropriate. It was prejudicial. In fact, it was prosecutorial misconduct, and a mistrial is warranted, citing a 1984 case. It says a prosecutor may not urge jurors to convict a criminal defendant in order to protect community values, preserve civil order, or deter future lawbreaking. The prosecutor may not make statements in closing calculated to arouse passions or prejudices of the jury. Now, in this case, the Court of Appeals has found improper government argument where they said that the defendant's conduct would lead to martial law being imposed. Not appropriate. Saying that the Proud Boys, quote, almost destroyed the Constitution is plainly inappropriate and highly prejudicial, and it was calculated. The government knows better. It was delivered at the very end of the rebuttal, literally the last words heard by the jury before deliberation. Nordine has been substantially prejudiced, and mistrial should be declared. Signed by defense attorney David Smith for the very inappropriate language being dropped by prosecutors. Destroy the Constitution? Give me a break. Not true at all. And DC Circuit Law says that you're not allowed to say those things. We'll see what the judge does with that one. Very likely what he does with all of the other defense motions, and just rules against them. That is the latest out of the Proud Boys trial. They have been excused for the day. Of course, we'll continue to check in. So thank you for subscribing and following along wherever it is you're watching this. And we'll look forward to seeing you on the next one.